remains unbowed and unbent in a ruling that came in an opinion that came out of the Tennessee Criminal Court of Appeals against J. Hirsch, Arthur J. Hirsch, the GMO-free traveler, the right to travel user of the public right-of-way, whose arguments went down in flames in the Criminal Court of Appeals in Nashville. We covered that case, and I've mentioned it to you before, but if you're not aware of this important case, it's worth considering and hearing a little bit about. It is, of course, humiliating to the day laborer and commoner, a private businessman, Jay Hirsch. He's 65 years old. He's also known as the fiddle man of Lawrence County, the fiddle man of Lawrenceburg, as a devout Christian, and has spent his whole life in law and politics, and has made the case for constitutionally guaranteed, unalienable, God-given inherent rights. These are rights that lawyers reject almost to a man, and judges are terrified about addressing, and even as we see in this case, terrified to protect. The court does not care to protect constitutionally guaranteed rights, and we want to mention just briefly now what it is that you have at stake. You have a lot at stake in this matter, even though you think, well, this is a marginal matter indeed. After all, we know that driving is a privilege, and that everybody drives, and in fact, it is part of the idiom, if you will, the idiom in America, that driving is the same thing as traveling by car and truck. We just use the word driving ignorantly and not really thinking of where it comes from. It is a word freighted with legal meaning, as many words are in the code. We have compound words and compound definitions of compound words. And as I was reading last night, I should have been reading the book of Daniel, which I'm under assignment to read today, but I read that this morning. And I should have read that yesterday, the Lord's Day, that is, in my estimation, to be given to resting in God's grace and thanking Him for His forgiveness, dealing with that in acts of mercy, and also edifying myself as a Christian by reading. Right, that's when I read my Eusebius church history, my Dobina history of the Reformation, my Bible, and maybe catechize a child. I used to catechize all my children pretty regularly. And I have only one at home still, age 14, and he indicates past being catechized in the Westminster Confession. But I was reading in title 54 and 55 that I'm committing to finish. I'm committing to finish this very large book. I'm holding this book up here before my viewer on YouTube. Thank you for joining me, and at Hot News Talk Radio channel, and also on Facebook at the Nooga Radio page. Thank you so much for giving me just a minute of your time. David Tulis here, covering local economy and the free markets, and arguing that you should love your neighbor and buy local. And so the arguments we make here for constitutional liberty are always about prosperity. Okay, you got to understand that prosperity, it comes when there's an equal playing field in the marketplace. No one party has advantage over another. The law does not allow a noble tribe to conquer the lesser types. And that's, of course, what we have. We have, because we have state licensing of all kinds of things, we have discrimination built into the system. Discrimination is built into the law. Some people can run free and clear. Others are bound. And we know that that's true when we look at police killings, just by the way, because police killings that we've seen over the weekend, just astounding videos online of black men, it happens to be, shot in the back. We know that there is a noble tribe called police officers, and they have they claim what the law forbids. That is to say, a title of nobility. They are unreachable by law. If you shot a man in the back under any circumstance, you would be charged with manslaughter or murder. They, on the other hand, can get away with it because they feared for their lives. That is a unique defense. And the people's patience is wearing thin. I want you to know, you, my listener, that your patience can continue to wear thin with my permission. Okay, you have permission to continue to be angry about this, and maybe even to the point of wanting the city council and the city government to do something about it here, because we have the same phenomenon here. Think of Javerio Eagle and others who, in God's providence, have been shot dead in encounters with the good people in blue. And so we have in this code here a system of obligation, of claim by the state against you. And Jay Hirsch is objecting to this, and he is saying, no, I have a right to travel. I'm sorry, I'm not asking permission to go from point A to point B. I'm not in commerce. I am not a common carrier for hire. I'm not carrying people or goods for pay. I'm using the road privately. I'm going to worship. I'm going to the jail where I play my violin. I'm going to the nursing home where there are many old Christians who don't know the first thing about the Bible, and yet they've been in church their whole life. And so I'm giving them words of comfort as they die in their faith. They're dying in their faith, though ignorant of anything about God's promises, as he tells me, with great lamentation. And I'm traveling there in my truck or my car. And so he was accosted in December of 2013 by Officer State Trooper Jeff Reed, Sergeant Jeff Reed, and faced trial in December of 2015 under Stella Hargroves in Circuit Court in Lawrence County. That's Middle Tennessee, so about 3 hours from here. And so the case went against him. The jury convicted, and many objections that he made, and what he called plain error, were obviously, even to me, not a lawyer, not trained really much. There were obvious plain errors. For example, challenges of jurisdiction. The judge said, "Well, we'll let you challenge jurisdiction after the trial." This is a wonderfully absurd, Kafkaesque line of thinking on the part of Stella Hargroves, who's a kind of a wild one on the bench, very wild, very lawless, you might say. Not pro-government, right? She's kind of not a pro-government judge because she is not in favor of the rule of law. Rather, she's in favor of her own pique and her own irritability, her own sense, or you could say her own censoriousness against this Christian man who made an articulate, very well done argument for his liberty. And so he was convicted, and there are two areas of conflict. One is the right to carry, the right to bear arms, and the limits on the state to regulate the wearing of arms. And all the court cases that Jay Hirsch looked up, the 65-year-old bachelor, indicates that wearing is a particular thing. Wearing in the Constitution is described in all the case law and all the cases that Tennessee courts have decided is something that's on your person. The word wearing is a weapon on your body, right? In your belt, in a pocket, in a jacket pocket, on your waist, in a holster, under your armpit, etc. That's wearing. And that alone is what the General Assembly has to legislate over, right? And to regulate. So it can theoretically demand that the man who's wearing a 45 Colt 911, Model 911, have a permit. Theoretically, we can assent for the moment, in pencil, that it has the authority to regulate that, but not more. So Jay had a 22 caliber revolver in a cooler in the cab of his truck. It was a sealed cooler, and he was convicted under the intent to go armed statute. So that statute is one that's it's unconstitutional, he says, because the word's not defined. Carry, intent to go armed, carrying an arm with intent to go armed, that is not defined. Neither is the phrase intent to go armed. And the High Court has said repeatedly that if not every word is defined and not every word is clear, then it is unconstitutional. So it's unconstitutional on its face. And Jay said this court doesn't have jurisdiction to hear this case because the law is flatly unconstitutional. It's unconstitutional facially, right? That's what the assistant DA Todd Ridley, the term he used is the oral arguments, and he wasn't really sure what Jay's argument was, whether the statute's unconstitutional facially or in application. It's unconstitutional on both sides, right? Both counts. On its face, it's unconstitutional. It's not a law. It's void for vagueness. It's not a law. Period. And so John Harris at Tennessee Firearms Association, when I sent him the case this morning, I think we'll have something worthy to consider about this argument. And so Jay was convicted on that by a jury of his peers. There is no right to bear arms in Tennessee according to the people of our state, people just like you, right? Swayed by the jealousy arguments of the prosecutrix. There were two of them, Kim Helper and Tammy Rettig, who handled the case. It took a day against Jay Hirsch. But I think the other case, which is perhaps more obscure, is really of more interest. And both of these arguments are shot down by this opinion. The author of the opinion is James Witt Jr., who delivered the opinion of the Court of Appeals, and that was from the July 18 session. It was really oral arguments made, and the opinion was filed on the 26th of September, so it's a few days old now, and I'm just getting around to looking at it. Sorry for the delay, right? You should count on me to have prompt reporting on things like that, but it's a case that no media outlet's covering, so I figure I can miss it and not be prompt on it, and I'm still beating the competition. Right? This is David Tulis. I do thank you for joining me. Now, the issue is this, and that is, did the 1937-38 General Assembly session and its passage of the Driver License Act, did the passage of that act destroy a constitutional right? Now, the way Jay Hirsch framed the issue is remarkable, and I want you to understand that it's remarkable because it's very simple. It's very, very simple. You know, the state can't have things both ways. Either, and here's how: either that law, which created the driver's license system, making people subject to the state for the act of driving, either that act is constitutional, and it did not destroy any right that the people had and exercised prior to its passage, okay? Or it's unconstitutional because it pretends to cover all uses of the public road and prohibit all uses of the public road apart from licensure, okay? So either it's constitutional because it's partial, it's constitutional because it deals with only some of the uses of the roads, but not all, or it's unconstitutional because it voids, nullifies, destroys, and eliminates a constitutional right that everybody had prior to the passage of that act in 738. So that's the issue. It can't have it both ways. It cannot have it both ways. If the act is constitutional, that means that there are people on the road today who do not have a driver license and who are exercising what Jay Hirsch calls a God-given, constitutional guaranteed, unalienable, and inherent right that belongs to you, my listener, because you're made in God's image, and you have rights that he gave you and that you can't give away, right? That's called the unalienable right. There are also inalienable rights, and they are ones that you can haggle and negotiate away, okay? There are rights that you can alienate, okay? You have a right, but you can alienate it, right? For example, I'd say that the right to marry is inalienable because almost everybody I know, with one or two exceptions, is married under statute, which means they married under permission of the state of Tennessee under the law, the positivist law of the Tennessee Code annotated. And they didn't marry as a matter of right, right? You have a right to marry from God. Marriage precedes the state, and it precedes the church. It belongs to every man and woman because they're made in God's image. And yet we say, I can't marry unless I get permission, not hear from the dad, right? Not from your bride's dad and mom. We're not talking about that one. We're talking about permission from the government. And Tennessee now says that marriage is whatever. It could make a monkey able to mate with a dog under its claim of authority over that area, which is really God's. Marriage belongs to God. It is a covenant. It is not a mere contract. If it is a contract, it's one far beyond in scope and claim than any other contract, right? It's not just business. Marriage is a covenant that God created. It is a unique, as the court cases will tell you, a unique contract between one man and one woman, period. No other thing is marriage. And so if the state can say Bob and Jim can marry and Jill and Annette, if they can marry, well, clearly it has destroyed its own claim upon that area of free human activity, right? So the question is about these rights. Jay Hirsch says that he has a right to travel, and in fact, the freedom of movement belongs to you. It inheres in you. It is a property right, right? You have. If you try to list all of the rights you have, and you had a notebook, and you start writing down all the rights and things that you had, you could probably fill out the whole notebook and not run out. Right? There's so many things that are yours free to do, in which there cannot be any prior claim against you. Prior claim that says you can't make that decision or do that thing without permission. There are so many things that are a matter of right. And I would say traveling and moving your private goods and your private people from point A to point B is one of them. It's an essential right. You can't exercise your rights if you can't go somewhere freely, right? You can't. The right of free speech, the right of worship. How can you worship if you can't get to your church, which is across town? Well, they told me in my case, you can take a bicycle, you can walk. They told me in my case back in the 2000s. And I was suing for a right to driver's license. I said, I have a right to driver's license. I'm suing for it. You can't prevent me. And in that case, the General Assembly rewrote a law to account for my arguments, and that is the law on Social Security numbers and whether or not you have whether or not you have a right to a driver's license apart from that. I was acting in ignorance, perhaps not knowing what I know now about that system. And I thought, well, if I'm going to travel and by car, I've got to have a driver's license, and they can't prevent me from having a driver's license if I don't have an SSN, which I don't have. I didn't have at the time. The judges said I had one, by the way. They said I had a number. They had no authority to say that, but they did. But anyway, in the Jay Hirsch case, he is saying that I have a right to travel in my private car, and made an able defense of his property rights. But the court essentially ignored, while the judges restate his arguments, I think fairly. They give a fair a description of what his position is. Though they call it scattered, they say that he's insisting this, that he's acknowledging that he also claims such and such. They turn then and ignore it. They say, well, these things really can't be argued here, and they're what we call technical reasons. You can't technically argue his main position. He can't argue his main position, and we can't really hear it. We can't rely on it for what I would call technical, lawyerly reasons. Here's what they said in part. It says, in his statement, which the trial court allowed in lieu of direct examination, the defendant acknowledged that he did not comply with the federal financial responsibility or motor vehicle registration laws. Notice the word acknowledged. And that's because they're taking judicial notice that somehow, or they're claiming judicially that somehow he did have a duty to. They're implying by the word acknowledged that he had a duty to, but that he acknowledged that he did not comply. So you see, they're already, even in trying to favor him by presenting his arguments from his perspective, they are undercutting his intent and I would say the law that he is standing upon. That he did not comply with the financial responsibility or motor vehicle registration laws, that he did not have a valid driver's license, and that he had in his possession a loaded handgun, as described by Sergeant Reed. He explained that he had discovered through his own research that because he was not engaged in commerce, he was not required to have a driver's license or obtain vehicle registration. He insisted that it was his God-given, unalienable right, that's correctly cited there, to travel freely and arm himself for protection, and that the state of Tennessee could not interfere with those rights by requiring that he register his vehicle, obtain a driver's license, register his firearm, or obtain a permit to carry his firearm. The defendant insisted, there he goes again, that he possessed the weapon solely for protection, and that he, quote, wasn't intending to go armed against anybody. He acknowledged, again, there's the word acknowledge. He acknowledged, however, that he was prepared to fire the weapon should the need arise. He said that the financial responsibility law was unconstitutional because it forced him to enter into an insurance contract against his will. The defendant added that the requirement that he utilize his Social Security number, notice that he has one, but of course he rescinded it, to obtain a driver's license or handgun carry permit violated his religious beliefs because the Social Security number was a precursor, was a precursor to the mark of the beast described in the book of Revelation. So this is in a nutshell, they say, here's what they say further in a couple sentences. In a nutshell, the defendant explained the requirements that he obtain a driver's license, car insurance, and a handgun carry permit, and that he register his vehicle, violate those rights accorded to him by the Bible, the Declaration of Independence, and the state and federal constitutions. That is correct. That is what he says. And so he was convicted on 4 counts. And the question now is, well, so what? Well, this is the most important case in the past 80 years, because it is from a complainant who is a belligerent claimant in person, arguing his case, as they say, pro se, in his proper natural person, as a man, not as a corporation. Right? He's doing this as Arthur J. Hurst, the man, the human being, apart from the trappings of the corporate status that is applied through your ID. Your ID is your legal avatar. He has done everything possible to eliminate that avatar, and he's arguing as a man in his flesh, which is, of course, a good position to be in because it makes your status easier to defend. Most people have a very low legal status, but Jay Hirsch has one considerably higher than yours and no doubt than mine. But the case is going to go up on appeal, and he's going to make an argument for the defense of the marketplace. You might say local economy and free market. That we can do things here in Chattanooga because we want to. Right? We can do things in Chattanooga because we are impelled by our personal interest to do them. Our personal character, our personal needs, our family needs, our business needs. And that we don't have to have the state in Nashville, which is 2 hours away from here, to give permission for the activities in local economy in the free market. Do you see why this matters? Do we want to have the permission from Nashville and Washington to do things on Main Street, to do things on Market Street in Chattanooga, to do things on Ringo Road in East Ridge, to do things on Gun Barrel Road, or any other lane or boulevard in Chattanooga and Hamilton County? Do we want permission of strangers through administration, through administrative law, through administrative agencies organized and governed by the UAPA, the Uniform Administrative Procedures Act, to control what we do here in Chattanooga as free men and women? Well, we don't think about this because we're not free. I understand that, but what I want to do here is to give you a sense of where we are and where we could be, right? We could be a freer people in Chattanooga. We could be, if we wanted to be, a holier and freer people and a more prosperous people. You know that there's a report that came out in Chattanooga.com Friday, a very significant document. I'll mention it later today, that talks about population growth. We're expecting to grow in population in Tennessee. Well, we could be a more populous state, a richer state, if we have local economy and free market. If we have an economy that does not depend on permission from alien bodies, from alien hovering satellites, which is what we have in these patrol cars. These patrol cars, these public schools, are alien ships that have landed, and they're hovering over Chattanooga, casting a large shadow over downtown Chattanooga. Now, do we accept that? Is there something we can do to get out from under that shadow? Is there something we can do to get rid of the obstacles to the sunlight? That's kind of what I'm asking about. And the missions conference at First Presbyterian Church downtown is looking into those questions as well. And it's doing so through the person of the Lord Jesus. That's the argument made by these missionaries around the world. They're all here in Chattanooga, giving a conference the next couple of days downtown, a missions conference on liberty.
The Tennessee Valley's news talk leader, Nooga Radio, digital FM 95.3 HD4 and 92.9